Thank you so much for having me. It's always an honor to speak to Professor Poggi's class, and I will try to explain a little bit about my experience with the issues that this class is dealing with in I don't know, 10 or 15 minutes, and open it up or go to the other panelists. So I'm assuming, by the way, at least a little bit of knowledge about the Chevron Ecuador case and the attacks that Chevron, along with some US judges, launched against me and other lawyers. But in a nutshell, sort of to cut right to the point of what I think the theme of this class is, from 1993 to 2011, I worked with a team of Ecuadorian lawyers to work within the legal system as we understood it to be, both in the United States and in Ecuador, to bring a lawsuit against Chevron for the admitted dumping of literally billions of gallons of cancer-causing oil waste into the Amazon, where 5 indigenous groups had lived in relative prosperity for millennia and really had seen their ancestral lands and their waterways essentially poisoned overnight period of about 10 years by a decision by Texaco to extract oil with a design that was intended to deliberately pollute, that is, to offload the waste directly into the environment, into the rivers and streams that Amazon communities in this 1,500 square mile area were using for their drinking water, their bathing, and their fishing. It really is worth repeating that an American oil company made a deliberate decision to pollute, to keep its production costs as low as possible, its profits, already high profits, even higher, as high as possible, in order to enrich its management and shareholders at the expense of literally some of the most vulnerable communities on the planet. It's important to understand that the communities impacted down in Ecuador were not poor, as we understand the word in the North. They did not have money as we know it, but they were very wealthy. They relied on the forest. They had good health. They had medicines from the forest. They had food. They had, before the oil company came, they had clean water, clean air. And it wasn't unusual to see people live to be more than 100 years old on a regular basis before the oil companies came. Each of these 5 indigenous nationalities had their own culture, their own way of life, their own language. None of the languages, by the way, had even a word for cancer before Texaco came. And when Texaco came and started to dump into rivers and streams, dump oil waste, the engineers for the company were confronted by some of the leadership of the indigenous nations about what the black stuff was in the water. And they told them that it was medicinal, that it had vitamins and was like milk. And that was a very common response by the Texaco engineers, who were continually mocking the local indigenous peoples whose habitat they were poisoning in a systematic way. And over the 25 or so years that Texaco engaged in this practice, people began to get sick and die of cancer. And I first went down there in 1993 as a young lawyer with a group of other lawyers and doctors to investigate reports of this massive pollution. And we decided to organize a lawsuit. At the time, I knew a lot less than I know now about how corporations react to these types of efforts to hold them accountable. But in any event, at the time, we believed in the rule of law as we understood it. We convinced some of the impacted communities to engage us as lawyers They would be clients for the purpose of filing a lawsuit against Texaco in U.S. federal court in New York, because that's where Texaco was headquartered at the time, and where Texaco executives made the decision to engage in this design that they impose on the people of Ecuador that resulted in the dumping of billions of gallons of toxic waste into the Amazon. The company's first response, and I'll tell you there's a playbook and a technique to how corporations react to these types of lawsuits, but their first response was to get rid of the case. Texaco's biggest fear, and I think this is typical for any big oil company or big chemical company or pharmaceutical company that gets sued for poisoning people, is to avoid a trial at all costs. Because in a trial, there's enormous risk for these companies, both reputational risk because evidence gets presented publicly, because the discovery process leading up to a civil trial means that their scientists and their workers and sometimes their executives have to testify under oath and tell the truth, because if they don't, they could be charged with a federal crime for lying under oath, even though it's a civil case. And you're often able to get documents from the company, even though generally speaking, most judges in the federal system try to handle the discovery process in ways that favor the corporations. You can still, the type of procedure that US justice imposes on corporations poses enormous risk. So they tried to shut the whole thing down. They tried to get it dismissed by filing a motion to move the case down to Ecuador's courts, where our clients lived and obviously where the pollution existed. And ultimately they won that battle. In 2001, we moved the case. The case was moved to Ecuador, but there was a huge silver lining because the court in the United States ruled that unless Chevron accepted jurisdiction in Ecuador and agreed to abide by any judgment, that they would not send the case to Ecuador and keep it in the United States, where the company would be subjected to what it really fears the most, which would be a jury trial, where citizens, that is impartial fact finders, would judge the company based on evidence we would present as lawyers. So having won that battle, which again was part of the first line of defense from the company, which is to avoid a trial, the US court sent the case to Ecuador. And that was, by the way, a 10-year battle in which many people suffered and died. Just the jurisdictional battle, where could the trial be held, took 10 years. I believe they thought we would go away because Chevron, by the way, Chevron had bought Texaco during this 10-year period. So we were now litigating against Chevron, which assumed all of Texaco's liabilities. And they thought we would go away because the case was being funded on a contingency fee basis, which is a common method in the law in civil cases in the US, at least, to finance cases where lawyers pay all the expenses and the clients agree to give them some percentage of the recovery for the risk they take. Usually a third, could be 40%, could be less. So that was our agreement with the clients. And we went down, and there was a law firm in Philadelphia that funded the case. I became very involved as a young lawyer, really organizing the local legal team in Ecuador. As an American, you couldn't appear in court. And ultimately, within 6 months, after this 10-year period of battling over where the trial could be held, we were in court on the first day of the trial within 6 months, once it got moved to Ecuador. On the first day of the trial, which you can see pictures of me in a court and also on the street of the town called Lago Agrio in the Amazon region of Ecuador, with a bunch of people, indigenous people in affected communities. On the first day of that trial, I knew we had accomplished something very, very significant. because the Chevron lawyers were so uncomfortable. And they looked like honestly freaked out by the fact they had to appear in court. And there were all these indigenous peoples, by the way, none of whom had even understood what a court was before we came down and explained to them their rights. There was sort of a deliberate thing going on in the country of Ecuador where like people were not empowered to think they had a right to go to court to correct the wrongs that have been done to them. So the very idea that this trial was starting in this place where Texaco had operated with impunity for 25 years. I mean, they openly dumped billions of gallons of oil waste and they've never been fined, much less held liable in a court of law for even $1. They were really nervous. And so their first line of defense failed. They then turned to other lines of defenses, including claims that even though they had promised to accept jurisdiction as a condition of the case being transferred to Ecuador, we got to Ecuador and they challenged jurisdiction, which is complete bad faith, in my opinion, unethical. And then over the course of the trial, which took several years, I thought it'd take like a year, but it's a civil justice system, not a common law justice system. And part of the process, I mean, a big difference between the two systems in the United States, UK, Canada, Australia, the Commonwealth, when you do a trial that involves scientific evidence, you basically have experts go into the field, gather it, and then come into court and testify about what they found. They get cross-examined. In the civil system, or at least in this case in Ecuador, which has its origins in Spain, the Spanish legal system, as opposed to the British legal system, the judge actually takes you into the field, and in front of the judge with no jury, you take water samples, soil samples, witness testimony at a particular site, and there were literally hundreds of contaminated sites that Chevron had left in this part of Ecuador. And this whole process of field inspections and gathering of water and soil samples, tens of thousands of samples, took a period of several years. And Chevron used that process, that very burdensome and I believe unnecessary evidence-producing process, to its advantage by making it as complicated as possible and trying to delay the trial as much as possible. And they would file literally hundreds of motions sometimes in a couple of day period and drive the judge crazy. And the judge didn't have enough time to move the trial forward. Their strategy was to sabotage the trial. So after they had lost the first line of defense, which is to avoid the trial, they then tried to undermine the trial and sabotage it. To make a very long story short, over a period of 8 years, we were able to get through that, and we won the case with a trial court judgment in 2011 in the amount of roughly $19 billion, which is a historic judgment. It's really the first multi-billion-dollar environmental judgment ever won in a court of law anywhere in the world, certainly in the global South, and certainly by the frontline defenders of the earth, that is, indigenous peoples. The irony, though, is at this point, Chevron knew it had lost control of the situation. It had lost control of the case, that the evidence was so overwhelming and the court system was strong enough to withstand their attempts at corruption that they expected to lose the trial. So they then went to sort of what I would call main defense number 3, which was to avoid paying the judgment. And the way they did that, in large part, was to try to go after me and other lawyers and claim that we had committed some sort of fraudulent crime to use the case to try to extort money from them so we could pay ourselves a big legal fee. That was their theory, which is not true. But they sort of put it out there first from a public relations standpoint. And then after we won the judgment in 2011, actually not after, we won the judgment on February 14th, 2011. So they could sort of get ahead of the narrative. They sued me on February 1st, 2 weeks before we won, claiming that the entire case, even though they hadn't even lost it yet, was a civil racketeering conspiracy orchestrated by me as the mastermind. Now, to be clear, a lot of lawyers worked on the case. I played an instrumental role. I get too much credit for what went right, probably. I mean, we got a great team of Ecuadorian lawyers, but Chevron needed what I would call a weapon of mass distraction. So when the verdict came down and they had lost, they could sort of claim it wasn't a valid verdict. It was a product of fraud. So they sued me 2 weeks prior to the verdict coming down, and they sued me back in the New York court where we originally had brought the case, where they refused to accept jurisdiction. In other words, the Ecuadorians wanted the case tried in federal court in New York City. They insisted it be in Ecuador. Once they lost or began to lose the Ecuador trial based on the evidence, they suddenly wanted to come back to New York to be rescued by a pro-corporate US judge. So they sued me under RICO. You might have heard a bit about RICO lately. Donald Trump and 18 other people have been charged under a criminal RICO statute by the state of Georgia. Georgia has a state RICO statute. There's also a federal RICO statute. And the federal statute was passed roughly 50 years ago by Congress to give prosecutors and other individuals really a tool to target the mob, the Italian mafia, which was very powerful in the United States in those days. And over time, the law, which allows a civil right of action, a private right of action. In other words, a prosecutor can use it to put you in jail. A civil case means you sue for money. It's like Chevron can sue me, or even we could sue Chevron for engaging in a racketeering conspiracy based on at least 2 predicate felonies. That's what's required by the statute. That is 2 crimes, at least 2 crimes. Group of people, conspiracy. So Chevron came up with this theory based on the federal RICO statute that our entire team was engaged. We're basically mobsters trying to extort money from them. And they made me the mastermind, and they sued me for more money than anyone in our country has ever been sued before in history, either prior or since, for roughly $60 billion, which is, it's funny you laugh, because I mean, when I heard that, it was so absurd. I remember coming home to my family, I'm telling my wife, like, hey, you're not gonna believe what happened today. I got sued by Chevron. She's like, well, what are they suing you for? And I said, $60 billion. And we looked at each other like if they had sued me for like 2 or 3 million, that's kind of scary, right? 60 billion is so absurd that like you can't even get your arms around it. In any event, it wasn't really about the money to them. It was about avoiding paying the people of Ecuador. And it was about creating a narrative, a false narrative, to distract attention from their crimes. So I then began, starting in 2011, a legal odyssey where I was being attacked ferociously by one of the most powerful companies on earth, an oil company, one of the most powerful law firms on earth, Gibson, Dunn and Crutcher, which literally use hundreds of lawyers on this case, and by one of the most powerful trial judges in the federal judiciary, Louis A. Kaplan, who's based in New York, who was appointed to the federal bench by President Clinton in the early 1990s. He used to be a tobacco industry defense lawyer before he became a judge. He's a really clever man, and he's extremely pro-corporate. He's extremely ideologically activist, in my opinion. And he, in my opinion, began to coordinate and collude with Chevron's legal team at Gibson Dunn to destroy the Ecuador case by essentially destroying me. I went through a RICO trial where I became the first person in US history ever to be named as a defendant in a civil RICO case without being given a jury. They denied me a jury. And the trick they used to deny me a jury is Chevron, on the 2 weeks before the trial, after this massive lead up to the trial where they tried to just drown us with subpoenas and depositions, they dropped all the $60 billion in money damages claims. Because under the 7th Amendment to the US Constitution, if in a civil case, you only get a jury if you're sued for money. So to avoid a jury, they dropped all the money. And we were all ready for a jury trial. I actually, despite the fact the judge was trying to rig the whole trial, felt like we could have won a jury trial. Juries are not stupid. They would see what's going on. They'd see their 50 lawyers in court and me and my 2 lawyers, and I'd get up and testify and they'd hear my story. And I don't think they would find me liable if we actually had a jury. And Chevron knew that because they focus grouped it and tested it with mock juries, and they knew they were going to lose. So they dropped all the money damages on the eve of trial. I insisted on a jury anyway, because think about it, the charges under civil RICO are predicated on proving felony offenses. But understand there's another trick they put in play, which is in a civil case in the United States, you have to prove your case by a preponderance of the evidence, meaning 50% plus an iota. Whereas in a criminal case, you have to prove all the elements of the crime beyond a reasonable doubt, which is 99.999%. So if I was charged with those felonies they use as predicates for the RICO, I would have been entitled to a jury, and they would have had an enormous burden of proof. But because Chevron charged me civilly with crimes, with federal crimes, they were able to deny me a jury and use a pro-corporate judge and not have to prove much of anything at all. So I essentially got criminalized through a civil case, which, by the way, is a much larger story and discussion about what's going on in the US and all over the world right now with the fossil fuel industry, which is systematic attempts to criminalize those who protest or lawyers who take on the industry. This case was like the beginning of that in a really big way in this country. That's since led to some other very disturbing developments in terms of free speech rights, but I digress. To get back to the point, they put me through what can only be described as a show trial, where Chevron paid a witness millions of dollars to come up from Ecuador. They coached him for 53 days before he testified, and they coached him to lie. And he claimed he was in a meeting where I approved the bribe of the trial judge in Ecuador. They had all my financial records, all the judges. There was never any bribe. There was never any proof of any bribe. It was only this paid witness's testimony that the US judge, trying to work with Chevron's lawyers to destroy the case and destroy me, credited as true. They basically framed me with false witness testimony in a civil case without a jury. In any event, because they couldn't get money out of me, they were able to get this big fat judgment, which they planned to use to show to judges in Canada and other countries where the Ecuadorians were going to go to seize their assets to collect on the judgment they wouldn't pay. They were going to show, oh, but a US judge found that Donziger committed fraud. You can't enforce the judgment. And it was really an intimidation tool directed primarily at judges in other countries who sort of are conditioned to automatically defer to US court decisions, particularly federal court decisions, because people just think the United States has the best judicial system in the world, the most fair. So if a U.S. judge found I committed a fraud, even though it was a show trial, it's extremely hard to convince people in this country or any other country that I'm right. You know, if it's a judge's word against Steve Donziger's word, it's not really a fair match in the eyes of most people who don't pay attention to the voluminous details of what actually happened. So they were very clever with the way they did this, and I became really put out into the wilderness. I mean, I lost a lot of credibility because of this judgment. Not because I deserve to, but because that's the way propaganda works, and it's the way corporate propaganda works. They basically laundered it through the judicial system to give it more credibility, because if Chevron said it, like, not that many people would believe Chevron, right? But if Chevron can get a judge to say it, a judge who appears impartial, even though he was not, it has a lot of power. And I got really hurt by that. It was hard to take on a lot of levels for me and my family. At the time this went down, my son was about 8 years old. And, you know, my wife, it was just hard to be that person in the United States in particular, where like your whole belief system and the system just completely collapses. In any event, we soldiered on. We sued Chevron in Canada with Canadian counsel and won a major Supreme Court decision in Canada against Chevron, giving the Ecuadorians the right to try to seize their assets in Canada. And by the way, they have about 25 billion worth of assets in Canada. It's such a big energy country that really scared them. They then went back to Judge Kaplan, given that I kept working on the case and organizing the Canadian counsel, and they were able to convince him to charge me with criminal contempt of court because I refused, on their theory, to give my computer and confidential case file to their lawyers. And their reason, their stated reason for wanting my computer was they claimed I owed them millions of dollars. Remember, they dropped all the money damages claims on the eve of the racketeering case. After I was denied a jury, the judge, and the judge ruled against me, they asked the judge to order me to pay them $32 million to reimburse them for their legal fees they used to persecute/prosecute me. And they essentially took all my money out of my bank accounts. They literally wiped out every asset I have other than my house, which is where I live now, and they can't by law take a person's home. So I have no bank account right now. More on that later. Ultimately, their strategy was designed to imprison me in my country. They did not want me to leave this country to go organize lawyers in other countries to pursue the Ecuador judgment against their assets, which in my opinion is why when I was in Toronto working on this case in 2019, the judge charged me with criminal contempt of court on the theory that I wouldn't give them my computer. And by the way, they said they needed my computer to get the money I owed them, according to Judge Kaplan, for their legal fees for going after me, which is really bogus. And when I appealed that order, because it's unprecedented, there's never been a lawyer in this country that I know of, that I've been able to find, who's been ordered to turn over his computer and case file to adversary counsel in a civil litigation. And Kaplan issued this order to put me in an impossible position, a dilemma between complying with a court order as a lawyer or complying with my ethical duties to my clients to protect this confidential information, which, by the way, they own the privilege to. It's their privilege to have confidential communications with their attorney. So this was a complete assault on my clients and on Chevron's victims. And I simply refused to turn over my computer. I didn't thumb my nose at the court. I appealed the order to the Second Circuit, but Judge Kaplan wouldn't give a stay. And in a civil case, if you don't get a stay during a civil litigation on a discovery question, you're supposed to comply with the order and then later appeal it if you lose the case. But the stakes were so high, excuse me, that I appealed it and didn't turn the computer over. He charged me with a crime. The judge, Kaplan, then took his criminal contempt charge to the U.S. attorney, that is the professional prosecutor in New York, who refused to prosecute me. And the judge then appointed a private Chevron law firm to prosecute me in the name of the U.S. government. Okay, I repeat, a U.S. judge appointed a private Chevron law firm to prosecute me in the name of the U.S. government. I was prosecuted criminally for this contempt charge, this misdemeanor charge, by Chevron, a Chevron lawyer, who asked the judge, who was a Federalist Society judge appointed by Judge Kaplan, I would argue illegally, to detain me prior to my misdemeanor trial. Another example of a first. There's never been a lawyer that I could find ever detained prior to a misdemeanor contempt charge in the history of our country. So they had this scheme, and this really, I think, goes right to the gist of what this course is about. Like, if you're trying to understand corporate responses to efforts to hold powerful companies accountable, this has to be one of the top exhibits, right? And they essentially privatize a public function of our judiciary to lock up their main critic. It's never happened before. It's never happened since. I ended up spending literally 993 days in detention on a misdemeanor charge where the maximum sentence is 180 days. Again, denied a jury. By the way, there's a little trick corporations use. I'll give you another one where under the US Constitution, if you're charged with a crime, you're entitled to a jury. It says it right in the Constitution. But judges have created a rule that if they agree up front prior to a criminal trial to limit your sentence to 6 months or less, they don't have to give you a jury. So again, to avoid a jury, the judge, Judge Loretta Preska, said she would limit my sentence to 6 months, and then orchestrated yet another show trial against me on the criminal contempt charge. So after I'd already spent more than 4 times the maximum sentence detained at home, she then detained me or imprisoned me for another 6 months before it all ended on April 25th of last year. So I served almost 3 years in prison on what I would argue is a manufactured crime used to silence and persecute a person who directly challenged this entrenched power that this oil company has. Not only power to pollute in the Amazon, but power to try to control our federal judiciary in a way that people like me or you or those in the world who actually are successful in holding them accountable get attacked and literally detained, jailed. And, you know, there were times I thought they were literally going to kill me. I thought they were, and, you know, I'm not out of the woods, by the way, because I still can't travel internationally. The judge refuses to return my passport. And I'm still going to fight for President Biden to pardon me, given that this conviction to me is illegitimate. And it's been determined to be that by the Working Group on Arbitrary Detention of the United Nations that already has one ruling in my favor. So I'll stop there. I hope that's not too long-winded. It's a long story. I'll make this one final comment, that the factual complexity of everything that happened, and I've just touched on a little bit of it in my presentation today, but the factual complexity exists by design as part of the corporate strategy. Like, they want this to be so complex that no one can get their arms around it, and then they'll just default to the fact, well, the court ruled this way, they must be right. Okay. The factual complexity is deliberately created by Chevron to confuse people and to make it virtually impossible for the average person to find the time to really read the primary source materials and understand what happened. You know, people say, well, the case has gone on 28 years. It's so complex. I'm like, actually, no, it's not complex. It's really, this is a simple case. A corporation went to the Amazon, and to keep its production costs to a minimum, dumped billions of gallons of cancer-causing toxic waste onto indigenous ancestral lands, and many people have died as a result. What the fuck is complex about that? Not a lot, right? It's a really simple story that they and this judge have tried to make so complex and try to distract attention from their environmental crimes and claim that I have somehow am the criminal. Me and my clients have, become, they try to make their victims into the criminals. And it's this whole criminalization attempt by industry to silence the ability of people to call them out and to do this work. So I'll stop there, and I'm happy to take any questions or participate in the rest of this seminar. And I apologize for taking up so much of your time. Thank you.
Stephen, I just want to jump in with one question. What is the current status of your case? And then secondly, what's going on in Ecuador? Because we recently hear about, the resistance continuing there. What's happened in the wake of this?
So I'll try to be a little more efficient in my answers. Okay, in terms of the case, there's really two cases. There's my personal case, and then there's the judgment owned by the communities in Ecuador. The second case is really the more important of the two, as much as I care about myself and my family. So I want to talk about that for a second. Once you get a judgment, and the judgment's been affirmed by Ecuador's Supreme Court and its constitutional court, there's no statute of limitations on enforcing it against the defendant's assets anywhere in the world, in any court in the world. So Chevron still faces considerable risk. Now, many people look at this and they think, I went to jail, I can't travel, the case is over, Chevron won. They really haven't. The fight goes on. And I think one reason they're so intent on making sure I don't get my passport back is because they know they face real risk, and they know I'm pretty good at my work, and I could organize lawyers in other countries to enforce the judgment. So I would say the Ecuador portion of the case is very viable. There are efforts by the communities to organize legal efforts in different countries to force the company to comply with the Ecuador court order and pay the judgment, again, from the court where they had accepted jurisdiction, and a judgment that's been affirmed actually by multiple appellate courts, both in Ecuador and Canada. As for me, I'm in a pretty tight situation. By the way, if you want to learn more about my thing, I have a website, freedonziger.com. But in a nutshell, I'm about to do two things. One is I'm about to file a motion to get my passport back. There's really no valid legal basis for them to confiscate my passport in a civil case. I've never missed a court date. I mean, it's pure retaliation because of, to prevent me from actually doing my job. And I'm also going to seek a pardon from President Biden, because I just don't think private corporate prosecutions comply with the rule of law or should be allowed in any country in the world, much less one that purports to have a separation of power system, purports to be ruled by the rule of law. And then, I'm also believe I'm entitled to monetary compensation from the US government for an arbitrary deprivation of my liberty in violation of the US Constitution and international law. Now, you might scoff at that. I'm not like waiting around to get a check, but I just want to mention this. The United Nations Working Group on Arbitrary Detention, which is a recognized international body where 5 international jurists look at cases of arbitrary detention and make rulings, issued a 21-page ruling describing my case as having a staggering and appalling level of bias in favor of Chevron by these judges. They ordered the US government to investigate how this could have happened and to compensate me for the arbitrary deprivation of liberty. This has fallen totally on deaf ears by our US government, meaning the executive branch, the Biden administration, Attorney General Garland, the State Department, who usually deal with decisions from this body. So I'm going to continue to press that and try to force the US government to deal with this fundamental contradiction where they act like they support the rule of law here and abroad and support democracy, but can't abide by a court decision from an international court that has called them out for violating the rights of one of its own citizens. So there's a lot to work with. I will say on a personal level, I don't want to get, I'm trying to move on. I'm writing a book, doing some other things now. And it takes a lot of time and energy, not to mention financial resources, to do this kind of advocacy. But I'm determined to keep going. So those are the answers to the two cases. In terms of Ecuador, you might have heard, a couple of things. One is there was a fabulous referendum passed recently, the Yasuni, to basically end oil drilling in a sensitive part of the Amazon. Ecuador really has led the world in a number of ways over the last 15, 20 years on the environment. It's the first country to enshrine the rights of nature in its constitution. That happened in 2008. Then there's our court victory. It's the first, major environmental court victory by indigenous groups over an oil major ever. And then this referendum was the first time a popular vote essentially ended oil operations of any oil company in world history. So there's a lot of interesting things happening, but there's a lot of not so good things happening as well, including the fact that Ecuador, for the last several years, has been governed by neoliberal pro-oil presidents, heavily under the influence of the United States government, the US State Department, US Embassy in Quito, and they've governed in ways that have really worsened the planetary crisis, worsened the climate crisis, and hasten the expansion of oil drilling. So Ecuador, in many respects, there's a major conflict. It's really a flashpoint. But you see this all over the world now, in the United States, Canada, so many countries, where indigenous peoples who sit on 80% of the world's oil and gas reserves are fighting governments and oil companies to protect their territory, their land, and ultimately the planet for all of us. So you see these conflicts playing out in really hot ways down in Ecuador. And our case, I think, is one example, but there are several examples. And if you sort of want a framework to understand, I think, some of the most important conflicts in the world today, you've got to look at conflicts between frontline indigenous groups all over the world, not just in Ecuador, but here in the US, the Thacker Pass lithium mine, up in Canada, the Wet'suwet'en fighting the Coastal GasLink pipeline. You're seeing this all over the place in Peru and Colombia, Brazil, with logging and mining in the Amazon. These are the battles that I think will determine the future of our planet. And indigenous peoples are on the front lines, and they need to be supported by everyone, in my opinion.
Any other comments, questions?
Yeah, I was hoping to talk a little bit more about the specific part of this, of your case on the kind of separation of powers. And in particular, you appealed that at the Supreme Court, they decided not to hear it. And Justice Gorsuch got a lot of attention for kind of the dissent that he wrote kind of in support of you and in support of, the separation of powers issue. So I'm kind of curious, particularly because, at first blush, we might think that, you and Justice Gorsuch make maybe strange bedfellows. And then in the result of this, in the wake of this, you had all of these liberal commentators and jurists and scholars kind of praising Gorsuch for that dissent. So I'm just kind of curious if you could talk a little bit about what it was like being at the center of all of that this past summer.
Sure, thank you for the question. Yeah, I mean, the whole thing is extraordinary, isn't it? Like, there's this private corporate prosecution. when that was over, I was lucky and blessed to get a really good legal team to handle my appeal, including Professor Stephen Vladeck from UT Austin Law School, like one of the best lawyers in the country. And also, I had some Federalist Society lawyers who approached me to represent me pro bono, and many of them had clerked for some of the conservative justices on the Supreme Court. I want you to think about that for a second, right? I mean, I'm a progressive lawyer. Like, there is virtually nothing that I agree with that any of the 6 conservative, some very far-right justices, Alito, Roberts, Clarence Thomas, Gorsuch, Kavanaugh, Amy Coney Barrett, like there's virtually nothing they do that I agree with. My lawyers are like, this is really wrong, what happened here. And I'm thinking to myself, by the way, I'm a sophisticated lawyer in some respects, but in others, law is so complex, it's so large. Like, I had no real understanding. Like, I knew a private corporate prosecution was wrong. I didn't quite know how to frame it legally in terms of the US Constitution. Like, there's different ways you can use the Constitution to make your legal argument. And these conservative lawyers who represent me, like, they're like, this violates the appointments clause in the Constitution, because you cannot have a government official who does not have executive branch supervision. I'm like, huh? Yeah. You cannot have a government official be employed by the US government without being supervised by the executive branch. I'm not going to bore you, but just say this. In the Constitution, the purpose of the Appointments Clause, I found this out from my lawyers, is to be sure that everyone who's employed by the government has some sort of accountability ultimately to someone elected by the people. Okay, that's why prosecutors are appointed by the president, or at the state level by the governor usually, or an election. Like, you cannot be a judge who's unelected and appoint someone who doesn't answer to anyone, doesn't work under the Department of Justice, which is an executive branch agency ultimately accountable to the President of the United States. Merrick Garland is appointed by Joe Biden. This was this bizarre situation where Rita Glavin, who's this Chevron lawyer appointed by Judge Kaplan, answered to nobody. I mean, she answered actually to Chevron, I could tell. They're writing her papers, you know, but she didn't answer. She's operating as the US government. She actually signed the briefs, Rita Glavin, for the US government, but she didn't work for the DOJ. She didn't work for the Southern District of New York. She wasn't a prosecutor. It was crazy. So this was really offensive to these conservative lawyers, not to mention liberal lawyers. I mean, and it really shows how bad it was, right? It shows that really this goes so beyond politics, like private prosecutions. There are so many business lawyers and conservative lawyers who told me how offended they were by what happened to me. And it was a real tactical mistake by Chevron, because they kind of had me down, you know? And when they did this private prosecution thing, a lot of people like started to not so much think about, oh, did I bribe the judge? Or what about this RICO case? And they sort of started to give me the benefit of the doubt. They're like, wait, if they're doing this to this guy, then maybe he has been right all along. And it really shifted the whole case in my favor. This is the crazy part. As painful as the experience was of being locked up, I'm just I'm seen in a completely different way now than I was 5 years ago. And I credit Gorsuch and Kavanaugh for, to make a long story short, we appealed it ultimately to the Supreme Court of the United States, and they listed it 5 different times for their conference. And for those of you who are not lawyers, trust me, it's highly unusual. They only accept 1 out of 100 appeals. They hardly do any cases anymore. They do like 50 a term. And it went into their conference, and we kept expecting them to like reject it. You know, it's like, kind of felt like it was when I applied to Harvard Law School out of college. I'm like, there's no way I'm getting in. And then I'm like, wait, I didn't get my rejection letter. Maybe I'm on the wait list. And it was kind of the same sensation. It was like, wait, they didn't reject me. And then like another week passes and they had another meeting. I'm like, wait, they didn't reject me. I mean, they're rejecting hundreds of cases. This went on for 5 weeks and I'm like, they're fucking debating among themselves whether to take my case. And ultimately they denied cert. There was a beautiful dissent by Gorsuch and Kavanaugh. Gorsuch, by the way, was in my law school class. I never said one word to him, didn't even know who he was at the time. And Gorsuch famously wrote, and I'll take this to my grave, he said, the Constitution does not allow what happened here. You know, and what upsets me and sort of shocks me is that none of the 3 so-called liberal justices or centrist justices, you know, Sotomayor, Kagan, or Ketanji Jackson Brown, join. All you need is 4 justices to get an appeal heard, 5 to win, and they wouldn't join. And like, to me, that just illustrates the depravity of that institution. I mean, one of the factors in terms of its, you know, deference to corporate power. So it really was disappointing. On the other hand, the dissent was really huge for me because I can carry that forward in so many ways. And I think it's going to be really difficult for another judge in this country, given that dissent, to, you know, allow another private corporate prosecution, even though the court didn't technically overrule it. They didn't rule in favor of it. And there is a powerful dissent from 2 very conservative justices that it is wrong. That helps me a lot and helps the people of Ecuador a lot.